Repeal and Consolidation. Repeal. There are also rather outdated and often ludicrous laws which are now in the statute book, but which have long ago ceased to have any meaning. In order to get rid of this issue, the Law Commission is drafting a statutory law, Repeals, bill to be enacted by Parliament. Through 2011, there were 18 provisions under the Statute Law, Repeals. Nearly 2,500 out-of-date Parliament amendments have been officially abolished. Moreover, portions of thousands of other laws have since been abolished. The 19th Statute Law, Repeals, bill was issued in 2012. This would result in the repeal of the 817 laws in their entirety and the elimination of the obsolete clauses from the 50 other measures. The argument that the statutes are out of date is demonstrated by the fact that the acts mentioned for revocation include the 1696 Act to collect funds for the rebuilding of St. Paul's Cathedral after the Great Fire of 1666, and the 4 19th century Acts to encourage the lighting of homes and streets with the use of gas lamps. This tie-up of the statute book aims to render the legislation more available. Consolidation. This is important since there are a variety of laws in certain fields of law, each of which lays down a particular portion of the overall legislation. The purpose of unification is to put together all the current laws in one act. This is another manner in which the legislation is rendered more available. The Law Commission creates approximately 5 restructuring bills per year, but it might be correct to claim that as soon as one region is merged, another region is divided by more Parliament actions. That was the situation for the punishment rule. The legislation was centralized in the jurisdiction of the Criminal Courts, Sentencing, Act 2000. Within a few months, though, the Criminal Justice and Court Services Act 2000, which replaced some of the collective penalties and even provided additional forms of punishment, modified the legislation again. Then, in 2003, the Criminal Reform Act of 2003 modified most of the punishment legislation again. Many changes have also been set in effect for juvenile prisoners and, in 2012, the Bill on Legal Assistance, Parole and Rehabilitation of Criminals made additional revisions to the legislation on parole. Codification. Codification means putting all the laws regarding one issue together under one frame of rule. It was explicitly alluded to in paragraph 3 of the Law Commission's Act 1965 as part of the position of the Law Commission. Indeed, when the Law Commission was first set up in 1965, an extensive codification plan was launched aimed at codifying family law, contract law, landlord and tenant regulations and the law of proof. However, the Law Commission has slowly discarded these major codification schemes in favor of what could be called the building block method. It focused on codifying specific parts of the legislation that could be applied to later. Indeed, the entire idea of codification is the topic of controversy. Many in support argue that it allows the legislation more open and understandable. It also provides clarity and certainty. The legislation is found in one location, so citizens will quickly figure out what the legislation is. The contrary opinion is that a very specific code renders the legislation more rigid, but if the code is written out in general terms and without explanation, it would have to be understood by the courts and will thereby remain almost as ambiguous as the current common legislation.